So I've had a lot of people that have had a hard time finding the time to come in and do estate planning. A lot of people are really busy. They don't really want to go into a lawyer's office and talk to a lawyer. They don't have the ability to get off of work to come in during the middle of the day. And so I developed a couple options for people to be able to get this important job done without interrupting their life too much. So the first one is the virtual estate plan, which you can learn about on my website, where we'll just meet through Zoom and do video chat and take care of an initial meeting that way. And then the second option, which I think a lot of the younger people that have pretty straightforward estate planning goals can take advantage of, and that's the documents only. And I'm going to talk about that now. So I charge $1,000 for documents only. And what that entails is basically you're going to go to my website, you're going to pull up the documents only form, you're going to enter your client key, and it's going to bring up the ability for you to enter information that I need to draft your estate planning documents. And now, while that might not seem the most personal way to do estate planning, I think there's a great deal of usefulness for this because estate planning over the last few years has become um, pretty straightforward in certain circumstances for individual or for married couples with minor children. If assets are under 22 million for the married couple, usually 11, because I like to make sure that if this law is rolled back in the future, we're still under that number without having to make too many changes. But for right now, $22 million, there's not going to be any tax. And so a lot of the younger clients want all their assets to go outright to their spouse and to have a testamentary trust for their children where they're going to pick who's going to be in charge of the money and who is going to take care of their kids if they pass away. And so I can get that done with a little bit of information along with some supplemental things about how each spouse would want to handle incapacity as far as who would pay the bills and who would make healthcare decisions. And so, really, I've offered this service because there are a lot of clients and a lot of financial planners I know who just say that I can't get my clients to do it. And I don't think it's that they don't want to do it. It's just that you always think I'll do that next year or I'll do it later. I need to do it. I'm going to do it. It's just not right now. And so this option is really to be able to say, okay, I know I have to do it. I'm eventually going to have to do it. Estate planning is pretty straightforward for what I want to do. I'm just going to fill out the form, get the documents ready, not have to interact with anybody until the signing time. And then I will go to the signing and sign everything up, get all the asset coordination information, and be on my way. And then I'll check it off my to-do list and not have to worry about it anymore. Um, the question I get a lot is why wouldn't I just do this on a self-help form like LegalZoom or documents like that? And the answer is that it's just not the same. Those are going to require a level of sophistication for you to understand what to put in there. And also, they lack a number of things like waiving inventory, waiving accounting. So there's going to be expenses that your executor is going to incur. You won't have your assets properly titled, and beneficiary designations may not send assets to the proper place. You might have leftover beneficiary designations that go directly to a minor child, which would cause a legal um, financial guardianship, which can be about $10,000 a year between the bond and legal fees related to keeping up with transactions and everything else, and just a lot of trouble for the guardians and the executor. So really, those self-help options may work if you're older and don't have any relatives and you just are trying to disperse of a couple things and don't have it and nothing's going to a minor. But really, it's not the best option for people that want to have things squared away. So as far as the time that it takes to do the documents only, I try to, once I get the documents in, your form in with your information, I'll draft them up usually that day. But within 2 days, I will get you back drafts, and it'll have a calendar scheduler where you can just click on it and pick the time that works for you to come in and sign the documents. You'll come into my office and I will have the whole process ready, all the documents sitting there. I'll go through everything, go through estate planning 101, make sure you understand everything. We can make minor changes if we need to, for names and things like that pretty easily. If we need to do something a little different than what the documents only do, then we may have to talk about a small fee extra to make sure that we get what you really want on there. But as far as signing it up, it's $1,000. Try to do it as quick as we can. I'll take down a list of your assets and make sure that I get you the information to properly designate beneficiaries and title accounts so that it flows with the estate plan that we've developed, and you'll be on your way. And so, like I discussed, there are some people that just can't qualify for the documents only. It's pretty specific. It's the married couples with kids, and they don't have to be minor kids, but a lot of times that's what I see. Things that don't qualify, unmarried persons, it just, we don't know where those assets are going to go. There's no standard way to do that. If you don't have children, it's the same deal. Assets over $11 million, we got to look at tax consequences. Real estate outside of Tennessee, if you own property that's in another state and it's in your name, then there's going to be an issue with having to transfer that property if something happened to you. So to do that, you have to probate the will in that state. And so typically when people have out-of-state real property, we're going to suggest that they do an LLC or a revocable trust to handle that property. Any children that qualify for government benefits, we might have to do a special needs trust to make sure that we don't kick them off a governmental benefit plan if we do something that we shouldn't in the will. And then children from a prior relationship, really, we have to do some planning to make sure that assets go where we want them to go as far as children, and not second spouse completely, which could leave out a child. And then also, if we're trying to disinherit someone, that's not going to fit. If we are going to, if your parents have over $11 million, we may need to think about some other planning. But a lot of times it's not going to matter until you actually inherit that. So we can go ahead and get something in place that's not going to be too expensive. And if that happens, then we can make some changes. And then if you're interested in doing a marital trust where assets go to the spouse and stay there in trust for their life and then go down to your children, then that's something we'll have to talk about, and it won't qualify. And so really, other than that, that's a lot of people fall in the buckets that can do it without those issues. And so I'm offering that service to make sure that people actually get their estate plan done and don't wait until later, or unfortunately till it's too late and they have a problem on their hands for their family. So basically, the important parts of the estate plan that we're doing on the documents only is we're picking a guardian to raise the children. We're picking a trustee to take care of the assets, avoiding a financial guardianship. We're making our decisions on who would be the backup to our spouse if something happened to us and somebody had to make healthcare decisions, and then somebody who can make financial decisions if we're incapacitated. So both of those are important and useful now, and our spouses even need those just to make sure that they can tell the doctor what we want to do and not leave that unattended to. And so really, if you're interested in this plan, we can talk more about the way the trust is designed, but it's basically one big pot that all the assets would go into if something happened to both parents, and then the trustee would take care of it from there, and that big pot would split into the number of children that you have at age 23 for the youngest, once the youngest hits 23 or graduates college, whichever is earlier. And then that way each child now has their own little bucket that if they spend money, it's coming off their pile instead of everyone's pile. In this option, we let the child become the trustee of their own trust at age 30. So each child would roll off at age 30 and no longer have to ask a trustee about using funds for themselves. So they still get the asset protection, and so they will be good to go from there. And really, that's all there is to the assets only, the documents only estate planning.